Hi folks, so it's the 24th of March 2020. This is the first day of our official lockdown. So what I've decided to do is I'm going to read this book here. It's a definitive book on prison law and has lots and lots of really interesting information about prisons. As you can see, it's a tome. And this book is used in court by the judges and by barristers when they're dealing with issues relating to prisoners. The book is what's called a practice book, and this book is is referred to as possibly the leading authority on prison law in England and Wales. It's got a number of chapters which cover a wide range of issues relating to prisons, and it's written by Tim Owen and Alison MacDonald. So what I propose to do is read through some of the relevant chapters. I'll give you an idea of some of the things it covers. It covers the legal framework and administrative structure of the prison system, talking about the history of the Prison Act, legislative framework, prison rules, prison service orders and instructions, complaints procedures, international law, security categorisation and allocation, living conditions in prison, healthcare in prison, access to the outside world and maintenance of family contacts, transfers, prison discipline, maintaining good order and discipline, women's prisons, children and young people, release from prison, fixed-term prisons, life sentence prisoners, immigration detention. So this is I'd say the go-to book, and it's very, very expensive. Right, what I'm going to do today then, I'm just going to give you a reading for about 20 minutes it probably won't even be that long really. A short reading of this chapter. This is chapter 2. The heading of the chapter is called Avenues of Redress Domestic Law. Okay, A. The fact of imprisonment invariably means that prisoners cease to have responsibility for and control over their environment. Living in a world governed almost entirely by the exercise of discretion naturally generates a wide range of grievances. The Wolf Report. Now, the Wolf Report was commissioned by the government after the Strangeways riots, which started on the 1st of April 1990. And they were classed as the worst riots in the history of prisons. And Lord Wolf set out a number of findings in his report. That's the Wolf Report. So, the Wolf Report recognised this, pointing out that a prisoner, as a result of being in prison, is particularly vulnerable to arbitrary and unlawful action. Arbitrary means random or without any obvious reason to do something. Accordingly, it is essential that prisoners have a number of avenues of redress open to them, whereby the illegal exercise of power may be challenged, and by which compensation can be recovered for the infringement of the rights which survive in all prisoners, notwithstanding their imprisonment. So as you can see, it's written in legal terminology. Not all of these avenues necessarily involved recourse to law. Indeed, as with life outside, by no means every problem which arises in prison is capable of successful resolution by legal means. In this chapter, therefore, we set out the range of remedies which are available to prisoners in order to redress the various grievances and complaints which arise most frequently in prison. So in legal terminology, a remedy is a means of either getting compensation or getting a result to sort of recompense somebody for something that's happened to them. Normally we see this in civil law. You don't have remedies really in criminal law. It's a civil private law term, really. However, if you're working in the criminal justice system, you will still need to know what it means, because people can also have a claim looking for a civil remedy that runs concurrently with a criminal matter. And you will be coming across, either in the probation service or dealing with offenders, where they are seeking a remedy. The extrajudicial options are largely those which are internal to the prison system itself, though they include recourse to the Prisons and Probation Ombudsman, Members of Parliament, and the Parliamentary Commission for Administration. These will be dealt with first under the general heading Complaints Procedures. The judicial options include 3 different forms of action: a civil action, usually involving a claim for damages for a civil wrong, brackets a tort, as I alluded to, private law; a claim for judicial review in the High Court, and we spoke about judicial review in the lectures, but I can go over that again; and a claim alleging an infringement of the Human Rights Act 1998. A fourth option, namely an application to the European Court of Human Rights in Strasbourg, that's dealt with separately. We do not intend in this chapter to describe and analyse the detailed provisions of tort or administrative law as they apply in the prison context, nor do we pretend that this book can be a substitute for specialist textbooks dealing with the substantial law and the procedure for both civil actions and claims for judicial review. Rather, our aim is to identify the appropriate means whereby the range of decisions and events which may affect prisoners can be challenged, and the particular features which distinguish legal actions by prisoners from other forms of litigation. As will in due course be explained, the division between different avenues of redress is not a rigid one, because it will frequently be the case that pursuing a complaint by the internal complaints mechanism will give rise to a claim for judicial review, possibly raising issues under the Human Rights Act. Indeed, in many cases, such internal recourse will be a wise or indeed essential prerequisite of mounting a successful challenge in the High Court. Bearing in mind this book is written for barristers, solicitors and judges. So this is when I talk about, when you're doing this, reading this degree, the level that you should be operating at once you've got one of these degrees is managerial. So these are some of the things that you will be required to report on if you're going to defend a claim. Hopefully, when you know all this, you won't have to defend a claim, because you'll put in procedures in your area of work that should reduce this. Okay then, paragraph or section B, complaints procedures. Under the prison rules, prisoners have the right to pursue a request or complaint connected to or arising from their imprisonment with the governor of the prison or the Independent Monitoring Board, brackets the IMB. Though there is no longer any express reference to this in the rules, it has long been accepted that in addition to these 2 avenues of redress, prisoners also have the right to complain to or petition the Secretary of State as the Minister with overall responsibility for the prison service and care of prisoners. In practice, of course, such petitions are dealt with by civil servants who act on behalf of the Secretary of State. In September 1990, a new system of dealing with prisoners' complaints requests was introduced by the prison service. The previous scheme, developed piecemeal over the previous 100 or so years, was generally regarded as unsatisfactory for a number of reasons. It was ineffective, slow, and lacking in coherence. The replies which were sent to prisoners, sometimes months after a complaint had been lodged, were almost always brief and wholly uninformative, thereby generating a complete lack of confidence in prisoners that their requests were taken seriously. Furthermore, the system lacked any safeguards to ensure that complaints were not blocked by staff, contrary to the requirements in the European prison rules that prisoners, individually or as a group, shall have ample opportunity to make requests or complaints to the director of the prison or to any other competent authority. Above all, the old system made no provision for independent review of action taken by the prison authorities. The sole power to remedy any complaint lay with the Governor or the Home Secretary, who was, either personally or through an agent, the author of the matter giving rise to the complaint. Boards of visitors, while nominally independent, had no power to take action without the agreement of the prison authorities and were, in any event, not regarded by prisoners as truly independent, compromised as they were by their disciplinary functions. This was raised by Lord Wolfe. And back in the olden days then, Wolfe recommended that the boards, they did like an adjudicationary function, that should be abolished. So the Board of Visitors used to get involved in disciplinaries, and that meant that the prisoners didn't really feel comfortable with them, and there was some suggestion of collusion between them and the prison management. Wolfe recommended it should be purely independent. And here we see the birth of the PPO. In turn, the system introduced in 1990 was subject to a major review in 1999-2000, which culminated in the issuing of a new Prison Service Order, PSO, on the subject, PSO 2510, the requirements of which were phased in during 2002. The review considered that the 1990 system was better than before, but still had major defects, and had failed to dispel the culture of defensiveness surrounding the issue of complaints requests. Before analysing the extent to which the new scheme meets the criticisms levelled at the old one, we summarise the existing provisions as they appear in the rules and administrative orders and regulations issued by the Prison Service. Heading: Prison Rules. The statutory requirement to provide some mechanism for dealing with prisoners' complaints and requests is to be found in Rules 11 and 78 brackets 1, which state 11 brackets 1. A prisoner may make a request or complaint to the Governor or Independent Monitoring Board relating to the prisoner's imprisonment. 2. The Governor shall consider as soon as possible any requests and complaints that are made to him under paragraph 1. 3. A written request or complaint under paragraph 1 may be made in confidence. 78 brackets 1. The Independent Monitoring Board for a prison and any member of the board shall hear any complaint or request which a prisoner wishes to make to them or him. There are a number of points to be noted about these provisions. First, Rule 11 requires the Governor to be available to hear any requests or complaints every day, full stop. Rule 81 enables the Governor to delegate any of his powers under the rules to another officer of the prison, where the leave of the Secretary of State is obtained, and Standing Order 5C confirms that the Secretary of State has authorised governors to delegate to any of their staff the task of hearing complaints pursuant to Rule 11. Accordingly, a prisoner cannot demand to make his request complaint to the number 1 Governor in charge of the prison, and, so long as a system is arranged for a member of staff to be available to hear complaints or requests every day, then the requirement of Rule 11 can be fulfilled. Secondly, prisoners can make their requests complaints either orally or in writing, but if they wish to do so in confidence, the request complaint must be made in writing. Rule 11 says nothing about the circumstances in which such a confidential complaint may be made. Rule 79(2) states that a member of the Independent Monitoring Board shall have access at any time to every part of the prison and to every prisoner, and he may interview any prisoner out of the sight and hearing of officers. But this is not the same as a right for the prisoner to demand that he be allowed to see the board member in private and in confidence. In addition, Rule 79(3) states that a member of the board shall always have access to records of the prison, except for any records held for the purpose of or relating to conduct authorised in accordance with the Regulation of Investigatory Powers Act 2000, which regulates surveillance and covert human intelligence sources. They're called CHISs. So when you hear the word CHIS, it's like somebody who's a prisoner or a member of the public or even another officer who is, in effect, finding out information to pass to the authorities. But they're allowed to do that. They're registered and they have to comply with certain rules. They're called a CHIS. Thirdly, the requirement of daily availability to hear prisoners' request complaints does not apply to the IMB as it does to the Governor. Rule 79 requires the members of the board to visit the prison frequently and to arrange a rota whereby at least one of the members visits the prison between the meetings of the full board. In practice, most IMBs ensure that one of their number visits at least 3 or 4 times each week. A prisoner who is dissatisfied with only seeing a single member of the board can reasonably ask to have access to the full board at one of their regular meetings. Finally, the rules say nothing about time limits for responding to a prisoner's request complaint. Although some details about time limits for responding to the complaints are contained in PSO 2510, a failure to deal promptly with prisoners' complaints could therefore be challenged by an application for judicial review. The complaints scheme in practice. PSI 02/2012 establishes a 2-tier internal complaints process. In PSO 2510, the different ways of making a complaint or request are defined in more detail. In contrast to the previous system, under PS 2510, requests and complaints are to be dealt with separately. Previous procedures have made no distinction between a request and a complaint. Failing to distinguish between the two can create a sense of grievance where none need to exist. A complaint system should be a means of redressing grievances, not of meeting everyday needs. Requests are therefore made using the informal wing applications, apps, which also form the first tier of the complaint system. This first informal level involves making oral or written applications to wing staff. Many of these now are done electronically on an ATM. This first informal level involves making oral written applications to wing staff, who should be available daily for this purpose, preferably in private. This informal procedure is intended to resolve the more mundane and trivial matters which arise in prison life. It is intended to be an intermediate process between simply speaking to an officer on the one hand and invoking the formal complaints procedure on the other. The second, formal option, itself divides into 2 stages or levels. Level 1, the wing stage, requires a prisoner to lodge a written complaint form, a form Comp 1, Comp 2 for confidential access complaints, or ADJ1 for appeals against adjudications. These are put in a locked box on the wing. So on the wing you'll see they're like post office boxes. Sometimes they're in yellow, sometimes they're in grey, and they're bolted onto the wall, and the prisoner can fill one of these in and put it in an envelope and put it in the box, which is collected at the end of the day. The boxes must be emptied each working day. The forms are required to be freely available without the prisoner having to request one. Lodging a form will result in the first instance in a written, reasoned reply being supplied by a prison officer. Level 2, brackets, the management stage, involves the prisoner submitting an appeal form, a Comp 1A, again in the lockbox, usually within 7 days of receiving the initial response. A member of senior management in the prison will respond in writing. If the prisoner remains unhappy with the response, he or she can appeal on the same form to the governing governor of the prison. That's the number 1. This is the final level of appeal in the prison service, after which a complaint may be taken to the Ombudsman. The governor is required to consider speaking to the prisoner about the problem, or asking a senior member of staff to do so. In addition to these options, PSO 2510 makes clear, as a safeguard, all prisoners may take advantage of confidential access to the governor of the prison, the chair of the Board of Visitors, now known as Independent Monitoring Boards, and or the area manager by lodging a written complaint on Form Comp 2 in a sealed envelope, which must not be opened until it reaches the person to whom it is addressed. Finally, prisoners are entitled to make oral or written applications to the IMB. Where none of these routes achieves a satisfactory resolution for the prisoner's point of view, PSO 2510 makes clear that staff must be able to inform prisoners of further avenues of complaint, including recourse to the Prisons and Probation Ombudsman, MPs, MEPs, the police, petitioning the Queen or Parliament, the Equality and Human Rights Commission, the Criminal Injuries Compensation Authority, individual legal advisors and organisations in the voluntary sector. PSO 2510 provides general guidance on how the internal complaint system should operate, leaving to individual governors to work out in detail how to operate the scheme in each establishment. It is important to recognise, however, that neither the order nor an individual governor's practice can override the requirements set out in the rules themselves. Thus, advice about exhausting the various options in a particular order is merely advice. Accordingly, it would be unlawful for the IMB to require a prisoner first to have raised a complaint with a wing officer before approaching it, and equally, the governor can make no such requirement before responding within 7 days to a written complaint addressed to him. In 1997, the Prison Service introduced a time limit for lodging a request or complaint form. This requires prisoners to submit any request or complaint form within 3 months of the matter under complaint coming to light. Only in exceptional circumstances will a complaint be eligible for consideration when submitted outside that limit, or where the prisoner can show good cause why it has been lodged out of time. Okay, I'm going to pause it there and I'm going to continue the recording tomorrow or another day, because I think 24 minutes is more than enough and you'll get bored after that. So listen to this then. Have a think about what I've said. And if you can, go online or go onto Microsoft Teams and read about the prison complaints procedure. I'll be putting some stuff on there.